So the flood of folks logging on seems to have stopped, so I just hit the recording button.
Welcome, everybody. Thanks for being here. I know there were a number of people who can't be here today, so we will do what we can, and of course, everyone is welcome to view the recording after the fact and send any further feedback that they have. On our agenda is a reminder of our fall meeting dates. I'm not sure if we really need to go over those. They're once a month at this point, but I think the important thing to note is that we only have a few more, so we still have quite a bit of work to do here. So we'll keep at this, and again, I appreciate all of the hard work that people are doing in the background to make these meetings productive. So we have the first item on our agenda today is to discuss the specific limitations on municipal court appeals that are different currently from the justice court appeals. And now I have lost my document, of course. I think I'm going to have to find it and defer to Jim, hopefully, to give us a quick overview of the specific issues. There's several issues, I think, about just sort of broad outlines. I mean, obviously, the big issue is that there's a difference between municipal court appeals and justice court appeals, and so do we want that or not want that? And then in what form, if so? So Jim, would you like to give a real quick outline of the several issues that we're looking at?
Sure. In 1954, in a case called City of Salem versus Polanski, the Supreme Court held that on appeal from the circuit court, in turn from an appeal from municipal court to circuit court, the defendant may not appeal and may only get review of the issue of the constitutionality of the ordinance or charter provision the defendant was charged with violating. That holding seems to have arisen from a provision in the statute that actually is limited to those situations in which the city has, by city charter or ordinance, stated that no appeal lies from a conviction of a violation of a charter or ordinance. The assumption of the statute appears to be that cities do have the authority to state that no appeal may be taken from a violation of a city charter or ordinance provision, perhaps where the fine imposed is very small. I have not been able to find any source of authority for a city to limit appeals for whatever reason, but assuming that either that it's there or that they have the inherent power to do so, the question is, should the limitation on the right to appeal, limited to the constitutionality of the provision, apply to all municipal court cases, or should only apply to those violations for which the city has stated that no appeal lies from it? What's curious about the Polanski case and other cases cited in my memo is that there was no showing, there's no statement or other showing that in fact the violation, the city charter or ordinance provision that the defendant was convicted of violating, that the city had declared that no appeal would lie from it. So we have this situation where the statute appears to limit appeal only if the city has declared that no appeal lies from the conviction, but the courts have applied it across the board to all municipal court cases. So the first major policy question is, first, am I correctly reading the interplay between the statutes and the case law? And if so, do we wish to restore what appears to be the original intent of the statute, which is to limit the scope of appeals to those situations where the city has in fact limited the right to appeal? Assuming that we do wish to do that, the question is, what is the mechanism? What we did in the first draft of our work bill is basically to take the existing statutes, repeal them, and place their essential provisions someplace else. But the word is either identical to or very similar to current law. And my concern is that if that's all we do, if the appellate courts take a second look at this issue, that they will simply reaffirm the holding of City of Salem versus Polanski and the other cases, and similarly limit the right to appeal. The other approach that I suggest is to get rid of that procedure altogether and to require use of the writ of review as the means to challenge the constitutionality of the ordinance. If you do that, then the parties can appeal from the circuit court's disposition of the writ of review. The appeal to the appellate courts necessarily will be limited to the constitutionality and related questions. And then once that is resolved and it goes back to the municipal court, a trial is held, and if the defendant is convicted, the defendant may appeal first to circuit court and then to the Court of Appeals without any limitation on the scope of the appeal.
Thanks for that summary. So I think first let's talk about the policy question of what exactly you think the policy should be, and then go into sort of the nitty-gritty details of how to do it. So I guess I'll just open the floor. Tony.
Yeah, I've always been confused by that statutory provision. I mean, I've tried lots of cases in what we used to do appeals from municipal courts, and I've never seen it that the defense raised by the prosecution that, well, you can't appeal because you're just appealing really the facts of the case. In other words, not any good defense lawyer can throw a constitutional issue in there and say there's something wrong with the ordinance or the statute. But I've just, in practice, I've never seen it used, so it's a little confounding to me. I think courts, I suspect municipal courts, my experience is mostly municipal courts, just allow appeals on everything. And I'm talking about misdemeanors, Jim. So I don't know if there's a different rule for misdemeanors, but I have not seen in practice it become any kind of a problem. I think appeals should be pretty wide open. Appealing in the ordinance, I don't like to see the cities have a chance to try to limit and keep everything in their muni courts or their justice courts. So that's my 2 cents worth. I don't think I said it very well, but that's all it's worth, is 2 cents.
For what it's worth, I can't speak to what happens on appeal to circuit courts in these cases. I can only speak to what has happened in the appellate courts. It's the cases that I cite in my memo. That's where the limitation on the scope of appeal has shown up, as far as I know. Now, circuit courts maybe do something differently, and I'm not sure it's necessarily clear that the circuit court is similarly, well, yeah, I guess the limit on the statutory limit, what I regard as the statutory limit, that is, the scope of appeal is limited only in those situations where the city has declared no appeal lies in that kind of case. I think that applies both to circuit court and the Court of Appeals. I'm hopeful that most of the cases that you took up to the circuit court, the city had not imposed any such limitation. And if they have not imposed any such limitation, then the circuit court would have total de novo review.
That's the way it was on the cases I had. I would not like to see cities encouraged to do something like this. I think it's got some constitutional problems anyway, if one were to, if a city were to try to limit these things, because the big consequences in misdemeanor cases on the citizens. I would not like to see any limits on those appeals.
I am sort of reading between the lines, but I think that what the statutory, well, I think what the legislature originally contemplated is that perhaps in extremely minor cases, such as a parking violation case where the fine imposed is $10, $20, $30, that the city could say you can't appeal from that, the same way that the legislature has said that you can't appeal from justice courts generally if the amount in controversy is less than, I think it's currently $30 or $50, whatever that limitation is.
But the wording of it would maybe leave the door open for something more than $20, those kinds of cases. And I would not like to see that personally.
Who else has comments? Melissa?
Sorry, I can't find the digital hand button, so I'm just going to raise my normal hand.
That's fine.
So the way the city has always, at least in past convictions that end up going up to circuit court from here, is that under 221359, if they are convicted, then they get a de novo appeal, right, in the circuit, because we're a court not of record. Under 221360, however, if it's based on some other reason, plea of no contest, plea of guilty, we've always taken the stance that it would be limited to the constitutional, to the constitutionality of the city charter or ordinance provision. That's been our position in the past when filing motions to dismiss. That's what we have always taken, and up until the point where we had to fight about pleas of no contest versus guilty pleas, generally the circuit courts dismiss based on that fact alone. So we would like that at least to remain intact.
Judge Britton?
I think this might also implicate the home rule policies that the state has embraced and supported. And I feel like League of Cities would want to weigh in on this if we were to make this change, and they might have strong feelings. And so I would just caution us, if we get the league involved, that could just complicate the bill from being this smooth consensus bill.
Okay, is that the total of the comments we have here? It sounds like it is a very good idea to I think we do officially have a League of Oregon Cities representative on this group. Am I right, Amy?
Scott Winkles receives all the invitations, and I think he's shown up once or twice since I started. Maybe once.
So maybe we should
Yes.
directly check in on this issue with him.
Yeah. Okay.
Any other comments? Okay, well, perhaps then, Jim, are there other aspects here that you'd like to talk about?
Well, I think all the other aspects flow from the basic decision of whether we wish to change the policy reflected in current case law. If we don't wish to change that, then it's just there's really not much left to decide.
Okay, so let's see if we can get an opinion from the League of Oregon Cities. Does anyone else think that there are others that we would need to check in with? Okay.
If I could pose a follow-up question to Judge Friends, did I understand you to say that the city of Eugene would seek to limit the scope of both the right to appeal and the scope of appeal to circuit court based upon the posture of the case? Is that what I understood you to say?
So I'm just a prosecutor. I appreciate it though.
Mm.
How we've proceeded in prior appeals over at circuit court, because Eugene is not a court of record. And how we've proceeded in the past is if a person is appealing based on a conviction from a no contest or guilty plea, we have moved to dismiss those cases based on the appeal not falling under 221360, which is appealing based on the constitutionality of the ordinance. And we've been successful in those dismissals. It's where a person is adjudged based on a jury or a bench finding them convicted under 221359 that they take the appeal and they can have their trial de novo. So I think what I saw was that the current draft was going to repeal 360. I would like that to at least remain intact. At least the concept itself, even if it's drafted elsewhere. But I'm not certain that we, the city of Eugene, has a provision within the city code that limits scope of appeals outside of what is in statute.
Does it trouble you at all that if a violation of a municipal ordinance is prosecuted in circuit court in the first instance, my understanding is that that prosecution would not be subject to the same limitation?
If it were removed from circuit, if it were removed from municipal court to circuit court, it doesn't trouble me because it would be in a court of record, and the basis for appeals de novo is because we are not a court of record.
I'll just pipe in. Melissa, I don't think that those objections should be, those ones you're talking about that you've made on pleas should be well taken by the circuit court because the city doesn't have, I don't think that statute applies unless the city has tried to exclude appeals and by its ordinance. And I don't think it has. So I'm a little confused by that. I'm troubled by that, Jim, and I don't like the idea that a municipality could decide to try to keep everything in-house and not have it see the light of day in another court, probably by any method. And that's one of them I can imagine would happen. On a plea, of course, what is a person to say? You're not going to raise in a notice of appeal that there was a constitutionality or an unconstitutionality of the ordinance. There may be, but you don't even get to talk about that. So the circuit court doesn't see that objection. A notice of appeal doesn't include much data. It's not a brief. So we'll get into the weeds further. I don't know if I think it's even a good idea to change the way it is now. People could appeal. I'm not sure that this group ought to try to change it, and eliminating would be great, but it seems like a big step. I'd like the idea of eliminating it because there'd be less confusion, but I'm not sure we ought to do that.
Any other comments? Okay, well, I guess we will table this one pending contact with the League of Oregon Cities and return to it. So the next thing on our agenda is the question of enforcement of judgments. And I think that my understanding is that there was some discussion in the scope and standard of review small group, I believe, about enforcement of judgments and whether the justice courts should be able to enforce the judgments that come from circuit courts after appeal. And there was some disagreement about that. And then after that, we've got OJD's feedback about what that would mean if justice courts were to be enforcing the circuit court judgments. And I don't believe the small group has reconvened since that point. So this is bringing it to the large group to look at that enforcement issue. And Lindsay, would you want to just summarize the state of the law, or do you want me to do that in your memo that you sent out? You're muted.
Oh,
Sorry,
yeah.
I tried. Oh, go ahead, Mr. Nass.
No, I'm sorry. Were you speaking to me or to Lindsay?
To Lindsay, yeah, to Lindsay.
Okay, good.
So we raised in our memo just a couple issues, both legal and practical, with this, the idea that a final judgment of conviction and sentence in the circuit court could be enforced by the local court. And I think, some of the practical considerations I think are really important. Issues such as dual enforcement at the same time of an order. If it's a circuit court judgment, then of course that court could enforce it. And if this provision says that the local court can, then I think there's a potential for confusion there. Also confusion for the litigant about who they should be remitting their payments to. And then I think there's just the general rule that courts have the authority to enforce their own orders and not the orders of other courts unless there's been some additional process. And so for those reasons, I think that the best way to move forward would be for final judgments in circuit court to be enforceable by that court only.
And that's OJD's understanding of the current state of the law. Is that correct?
Yes.
Okay, so discussion.
I have a clarifying question. Are we deciding anything right now, or is this to be tabled for later? I just think that there may be some comments from other people that does not include myself. So
well, I think we were hoping to decide it today, but if we can't do that, then we can't do that. So we'll do what we can.
So final, just to clarify too for Lindsay, it would be final judgments to be enforced by OJD. So any fines, I guess imposed would be collected by OJD, correct?
Yeah, and I will add just to what I said before that there is that the statute 221390 that talks about payments being remitted to a lower court. I think to me that where the money goes after it's received by the court that it's owed to is a different question. So the disbursements, I think, is a separate question. But the court that has issued the judgment requiring payment and how that's enforced, I think is what we're discussing here.
Jimmy.
Sure. So I think this is an issue that can't be decided in a vacuum. There are really two issues that play into each other. And one of them is which court should the final judgment be in at the end of the day when there's an appeal? And the second question is which court should enforce the judgment? And I think the policy implications of either of them depends on the other one. So I think, and Jim's memo does a very good job of this, is dealing with them together, which is why I like Jim's proposal. I think what sort of seems to be going on now is maybe some stuff that's kind of ultra vires. I think justice courts want to have authority over judgments from cases that originate in their court, even when under current law, the judgment is always being entered in the circuit court when there's an appeal. I think that might be creating some problems. I think Jim's proposal has some very good solutions to keeping maybe more of the final judgments in the justice courts and then letting them enforce them, but also keeping at least misdemeanor judgments in the circuit courts and making clear that it's circuit courts that have the authority over those judgments. I think that strikes the right policy balance, but I don't think we could consider one of those questions in artificial isolation. And I think Jim probably could do a better job than I can of explaining why that's a good idea.
I am not sure that I can, but the premise of my August 4 memo is that I agree with Lindsay that only one court at a time should be enforcing a judgment. But at the same time, I was trying to think of a way, is there a way that we can retain the authority in justice and municipal courts to enforce the judgments rendered in cases that originated in those courts? And I think we can do that if we reinvigorate the current statutory authorization for circuit courts, in essence, simply to affirm the justice or municipal court where the circuit court agrees that the defendant is guilty and would impose the same fine that the local court did, which in violation cases, as far as what I've been able to tell, is probably most of the violation cases, perhaps in part because the statute sets out minimum, maximum, and presumptive fines. So presumably in violation cases, it shouldn't matter whether it's the municipal court or the justice court or the circuit court. The presumptive fine is pretty clear. So in most cases where the circuit court determines that the defendant should be convicted, it simply could affirm the decision of the municipal justice court. And so the operative judgment would be the judgment entered by the local court, and the local court could proceed to enforce it. I was persuaded by Jimmy that misdemeanor cases are different. So misdemeanor cases, the circuit court should, in virtually all cases, enter its own judgment, which would be enforceable only by the circuit court. But that in violation cases, at least the circuit court should have the option of simply affirming the disposition reached by the local court.
And can you remind us why this distinction?
Pardon? Oh, I would, because affirming the local court means that the operative judgment would be the judgment rendered by the justice or municipal court, and it could then proceed to enforce that judgment rather than having the circuit court do it.
And the distinction between violations and misdemeanors.
I can take that if that's okay. I think for several reasons. One, misdemeanors, unlike violations, have a lot of other statutes, particularly in Chapter 138 about post-conviction review and appeals that are not going to work if the final judgment is not in the circuit court. Misdemeanor cases also, unlike violation cases, there are a lot of moving parts in their judgments. There's not like one presumptive sentence for a misdemeanor case that every court across the state is going to impose. Each court is going to have its own preferences about, say, which probation conditions to impose or exactly how much jail time to give. And there's not a lot of guidance giving the courts in those cases. So there's really not going to be that many cases where there'd be straight affirmances of the circuit court's going to do exactly the same thing as the justice court. Any two judges are probably going to sentence misdemeanors slightly differently. So you don't really have the sort of straight affirmances that you would get in violation cases. So those would be the two reasons. But the big one is that there are just a lot of other statutes that interact with misdemeanors and that would not work appropriately. We'd have to make a bunch of other changes to accommodate it if the final judgment was going to be in the justice court.
I note Justice Kidd's comment in the chat saying that I think Jim's proposal strikes a good balance between competing interests. Are there other comments?
Well, I rarely like to say out loud that I agree with Jim, but I think in this instance, I do think that there's the Jimmy's rationale on distinctions between misdemeanors makes sense. But I think that the striking the balance with regard to the judgments being essentially remanded to the justice court where there is no or very minor changes makes a lot of sense and strikes a good balance there. So I support the proposal put forth on the August 4th document.
Justice Brisbane?
Also, section 20 of working draft 4 currently addresses the fact that if there is a money judgment in circuit court would notify justice court who could enforce the monetary provision. That applies to both violation and misdemeanor cases. So that would need to be modified if misdemeanors are no longer part of that. But the other part of it is if there's a dismissal or a not guilty finding in circuit court, justice court also needs to be notified because justice court may have taken action against someone's driving privileges, or DMV may have an abstract of conviction that the justice court needs to vacate. In other words, circuit court should notify justice court of the disposition so justice court can take the appropriate action to enforce the correct judgment.
Yeah, and I think Judge Brisbane is referring on page 16, section 20,
right.
subsection 2. Isn't
Right.
that right?
Yes.
It says the justice court has the authority to enforce any monetary provisions of the judgment. And I think what Jim's proposal is, it would actually remand that so it's the justice court is not enforcing the circuit court judgment. It is in fact a justice court judgment that is then being enforced, which I think would just clean up that potential issue. I think Jim's proposal does that. We just have to make sure that the section then reflects that. Am I saying that correct, Jim?
Yes, we would have to modify section 20, if not repeal it. Yeah, yes.
Doesn't it seem very confusing for the defendants that are going back and forth and back and forth and back and forth? I really so strongly believe that if they leave a lower court that's not a court of record wanting an appeal and ready to jump through all of those hoops, they no longer believe in that lower court. And if we're sending them back and forth and file this here and then you've got to come back here, I think they're losing faith in the system, and we've got a real potential for fines not to be paid and people to be sent to collections and spiral out of control.
I think I agree with Emily, and I will say that from the point of view of defendants, I think the last judge they saw and pronounced the sentence is probably the one that's the authority figure that they should be looking to for orders, whether it's money or jail or whatever. And you don't want folks don't have the bandwidth, as they say, to get back and forth from the different courts. So I think the last judge that the litigant saw, that's the law, and that's what the person should be looking to for the directive to pay a fine, go to jail, stand on their head, whatever it is.
Can I just clarify, does this have a fiscal impact where the judgment is entered? Does this mean that fines are going to the justice or municipal court instead of the circuit court?
The first 50 would go to the state, according to our allocation statute, if you're a municipal court. The first 50 collected of the fine would go back to the state. The last 15 would go to the county, and then the municipal keeps the stuff in the middle.
Justice courts
Same
are
rule
the
for
same.
justice. Yeah, justice courts and municipal courts follow the same statutes for fine disbursement.
But we're not changing anything about the disbursement, correct? It's just the judgment entry. And Kristen, it's your question. Is there anything in judgment entry that would affect disbursement?
Well, the
Oh,
circuit court would retain the fine. If circuit court disperses it, then circuit court keeps the fine and sends the last 16 back to the county for county assessment. If justice court retains the fine or municipal court retains the fine, they send the first 50 to the state. The county or city retains the fine, and the last $16 goes to the county if the fine's collected in full as a county assessment. County assessment helps pay for drug and alcohol treatment programs in the county and also for the court security fund. That circuit courts and justice courts can get money from that court security fund to run their operations. Or obtain equipment. Actually, they can't pay for staff, they can pay for equipment.
Judge Brisbane, which statute talks about the disbursement of the fines?
It's in 153. I don't have it memorized, but I can look at it and I'll mute myself and come back.
I'm just wondering if anyone knows off the top of their head if these are for all municipal justice courts or only
Yes.
municipal justice courts that have adopted the ORS, or how it works.
All of them.
Okay, thank you.
And then as to whether or not it would be a fiscal impact, I think, at most we're talking of a couple $100, maybe $1,000, but appeals aren't that common, and the folks that appeal generally don't always pay their fine in full anyway. So, we have judges that somebody just posted on the listserv that they're appealed for the first time in 10 years. So I think the financial impact to any municipality would probably be minimal.
And just to clarify one piece, the circuit court does not keep the vast majority of the money. It's almost all going to the state in criminal fines. And then split depending on citing agency. But there's a very, very small amount that is retained by, like, say, the court-appointed counsel account, if there's court-appointed counsel in a misdemeanor case. But again, it's all governed by statute, but I do think that there are differences depending on the court that the judgment's entered in.
And I certainly misstated who's getting the money if the circuit court enters the judgment, but I guess the clarification that I was looking for is what you just said. It does matter which court the judgment is entered in. So everyone thinks that if there's a judgment simply affirming the local court's ruling, that doesn't affect the question of which court entered the judgment.
I think the case would have to be remanded, back to the local court then for the local court's financial judgment to be the enforceable judgment, and for that court then to enforce it. So there would have to be that step. But again, Jim's August 4th document sets that out clearly and distinctly.
Jimmy?
Yes, I actually think there wouldn't even need to be that step necessarily, right? The Justice Court has already entered a judgment, and the Circuit Court is going to enter a judgment of affirmance, which isn't going to contain like an additional money award. It's just going to say, affirm the judgment of the Justice Court. And that Justice Court document that's already there is going to continue to be the active judgment after that. So there's not even a need for the Justice Court to enter another judgment. It just stays in place. That at least is the idea as I understand it. So it shouldn't affect anything.
In case you want the statutes, 153.640 is disposition of fines for traffic offenses in circuit court. 645 is justice court, and 650 is municipal court.
And going back to your question about a fiscal impact, I think if I'm understanding this correctly, that if we're changing the way that it currently operates, then maybe we could project a revenue impact for the state. But I again think that it would be very, very minimal. But if we're changing it so that there won't be these de novo trials that result in judgments of conviction with money awards in circuit court, and changing those to remands, then there could be a very, very small revenue impact.
Part of the rationale on that, of course, is that there's the appeal. The circuit court has received the fees, the statutory fees in the case to which, with the notion that covering the economic costs and impact there, which I think is just another rationale for the judgment. If the local court is affirmed, that makes economic good sense for that judgment then to return or to remain with that court for enforcement.
Okay, so I guess do folks need to do more thinking about this? Are we at the point of being able to move on? It sounds like I'm hearing probable consensus around Jim's proposal, but I'm not sure if everyone's there yet. So speak up if you'd like to.
I think just for my due diligence, I'm just gonna forward this to whoever in the city I might need to, and then we will circle back.
So other than Melissa, are we in consensus about Jim's proposal?
I don't have any issues with the policy, but I'd like to spend a little bit more time with the details just to make sure that we don't have any just technical feedback on the wording or how it would be, just to simplify. So I would like a little bit more time on that piece.
Are you talking about today or at a different point?
I will do it as soon as possible, but definitely a few more days.
Okay.
Thanks.
Okay, great. Well, if there are no other concerns at this point, then let's just table it for the next time. And any new feedback, please send us as soon as you can and before the next meeting so that we are aware in advance. Okay. So we have gotten through this much faster than I expected, and I guess we did not send out the scope of review scope and standard of review and disposition memo again with this agenda. We didn't get through the disposition portion of that memo at the last meeting. So I guess we will not address it here, but I guess that's what we still have as far as outstanding issues that we haven't addressed yet, I believe. Jimmy, you have your hand up.
Sure. I will just flag a big part of the disposition stuff was kind of the stuff we just covered right now. And what we just covered represents kind of a different policy than what's in the memo. So some of that we don't need to cover again, and it's now outdated.
Okay, so perhaps can I prevail upon you to let me know what we should be addressing apart from what we just addressed and is still outstanding in the interim between now and the next meeting, so we make sure we get everything out there. I know we didn't quite resolve the question of conditional pleas versus the transfer question, and again, we didn't have that on the agenda today, so we don't need to go into that, but I'm aware that's out there. And other than that, we need to talk about default judgments. What else, if anything, are people aware of that's outstanding as far as big questions? Justice Kidd?
Yeah, so there are a couple things on the civil side that we just never have talked about, and I know we're kind of keeping that for later, but whatever we do on defaults, we should address that on the civil default. And there's some really specific things with FED practice, eviction practice, that we should make some policy choices around. For example, there are certain rights that attach at a trial, like a right to redemption. And so we may want to specify whether somebody's taking a second trial, whether the right to redemption still exists or things like that, right? So there's some civil stuff that we just haven't talked about at all.
Okay, at this point, just to be clear, we're not trying to retain any civil stuff off of the table. So if there are new issues that we haven't discussed, please let us know at this point. So Justice Kidd, do you want to maybe email me a little bit more detail so we've got that?
Sure.
And are there any other issues that we haven't mentioned yet that folks want to address? Okay,
What's it, when you talk about the transfer, that an email I sent you this morning on with regard to section 5, subsection 2, is that part what you intend to include in finishing up the transfer stuff?
I'm sorry, I haven't seen your email.
Oh, I apologize.
I've been tied up all morning, so
I know, and I was tired. It's been a rough couple weeks. Anyway, section 5, subsection 2, which is on page 5. Just to give a quick synopsis, it talks about an adverse ruling, pre-adjudication ruling, and the parties can request a transfer to the circuit court. Now, is that an appeal? Is that not an appeal, or is it an appeal that invokes the fees and the costs involved in that? Because I'm puzzled. It doesn't seem to fit in with the scheme that exists everywhere else, unless we're using the word transfer in a way that I'm not understanding. So I think that's an issue that kind of a bigger issue that we do need to clarify. So at least clarify to me. Maybe I'm just thick and I'm not getting it, but. Otherwise, it just seems like it seems like the party's getting essentially a free bite and an advisory opinion from the local court, and then they can just transfer the case without any cost to a circuit court and try it again.
So what this provision does, and Jimmy could probably speak to it better than I can, but Jimmy's memo from way back raised the issue of whether conditional plea should be allowed in justice and municipal courts. And Jimmy made the point that when you have de novo review, a conditional plea doesn't make much sense. But that defendant should be allowed to say, okay, look, if this is a constitutional statute, or if the search was constitutional, I'm guilty and we don't need a trial. And so it's typically a pure legal issue that has to be resolved one way or the other. And since the defendant has the right to de novo appeal, there's no sense of going through the process in the justice or municipal court, resolve the legal issue, and then take a de novo appeal, but rather the case should just be transferred at that point.
Can I just jump in here? Because this is the conditional plea issue that I was just saying that we started addressing last time. And didn't get to. So that is the issue, and we'll need to address it, but it wasn't on today's agenda, so I don't think people are really prepared to talk about it.
And I get that. That's why, but I wanted to make sure that was, when you mentioned that we were going to deal with that later, I wanted to make sure that this section was in fact in that intended topic area.
Yes, it is. Thanks for that clarification. So if there are any other issues, and thank you for bringing that up, if there's any other issues that have not been raised yet that feel need to be addressed, please do email us and let us know, because we do need to have a really comprehensive list at this point of anything else that needs to be addressed. But we are getting through this. Of course, the default judgments issue is a difficult one. We thank you very much for everyone that sent back the surveys, and as is not surprising, there are some strong differences of opinion that remain on this. And so I think the question at this point is, we have some strong positions on wanting a de novo or a trial a new standard, and strong positions wanting a abuse of discretion standard. At this point, the question is, how are we going to resolve this issue? It's my perception from the recent case that came out that if we are, well, that the current law is unclear, it's not decided about what would happen. And because we are changing the way that the current law is written, it's kind of impossible for us not to address the default judgment issue. And so I don't think it's really an option, and anyone is welcome to correct me if I'm wrong, to do nothing about this. We have to address it in some way. So we are going to need to figure out how to deal with the fact that there is really not any consensus at this point on the standard of review question. So if anybody's got any ideas about how we can resolve this, let us know. Otherwise, leadership will be talking about it, and we will let you know what we're thinking. So anybody want to comment on that at this point? We have a few minutes, or that, or anything else that anyone would like to comment on. Okay. Well, for the first time ever, we are going to end 3 minutes early. Thank you, everyone, and keep the comments coming. And take care.